Good morning, Carla Hartley here. Today I'm going to be discussing a disturbing case that raises the standard of care for attorneys across the board. All right, for family law attorneys, we have had a long-running debate as to whether we should be responsible for investigating the claims our clients are making before we sign off on that RFO, which is a request for order, or filing with the court. Many attorneys have historically preferred not to investigate what their clients are telling them because they want to simply set forth what their clients are saying and let the chips fall where they may. That has never been our practice at Hartley Lamas. It has certainly never been the practice at any firm where I have been prior to forming my own firm. So I want to say that this is why I'm aware of the discussion. Also, I previously practiced in federal court. I'm still licensed there, and in bankruptcy in particular, you have a duty to investigate what your client is telling you. In federal court, you have, when you're filing a pleading, you've got a duty of investigation. There's a case that just came down. It's called OShea v. Lindenberg. It was ordered published on May 14th, 2021. And this case is significant for family law attorneys practicing in California, because in this case, an attorney, a well-regarded attorney apparently, decided to not investigate his client's claims, is what it looks like to me. The client signed 2 income and expense declarations, apparently, that were perjurious, later found to be perjurious, and as a result, the man's client ended up in a situation where he was hit with a massive award of attorney's fees and costs as sanctions. I think it was $125,000. $135,000 was the fee award. So this client fires his attorney and hired a new one, and then sued the first attorney for malpractice. The disturbing part to me about OShea, the OShea case, is that the court found that he had committed malpractice by not exercising the appropriate standard of care with regard to the client. Now, the language in this case appears to indicate that is because the attorney did not investigate the client's claims in the 2 perjurious income and expense declarations. So now we have something where we have people who have signed an income and expense declaration under penalty of perjury, have provided documents to the attorney stating that this is what I am earning, and when in an adversarial proceeding it comes out after hearing that none of that was true, that it was vastly underestimated, and some of the claims were not made with good factual support, the attorney was found to have committed malpractice. Now, OShea is comforting because the standard in these types of cases, attorney malpractice cases, are that the client must prove that he or she would have obtained a much better order but for the failure of the attorney to exercise due care. That's the reassuring part, because for the most part that's very, very difficult to prove, and you're not going to see that in family law cases. The more important thing, though, is there is a finding of malpractice for failure to investigate the client. That is not the specific language of OShea, but if you're reading OShea, that is what is being put onto us as family law attorneys as our burden. I don't know if this is going to survive. I have no doubt it's probably going to head, or at least somebody's going to try to get it before the Supreme Court, maybe try to get it depublished. But this is the way the wind is blowing. So I would say to those attorneys who are out there who think, yeah, I don't have a duty to investigate, you probably should. And to clients who have attorneys who don't want to investigate their claims, I would suggest to you that family law is often referred to, sometimes jokingly, sometimes sadly not so jokingly, as the palace of perjury. It's not just often perspective. Sometimes it is outright untruth that gets issued in these cases. If you have an attorney that is not looking for corroborating evidence, if you have an attorney that is jumping in and filing motions without looking at the documentary evidence or talking to any kind of witness whatsoever, trying to get the information from you about what will corroborate your story, what will corroborate your factual assertions that you must make in your case to prevail, you need to maybe consider getting a different attorney or doing some investigative work on your own and requiring your attorney to start putting this stuff out. Now, I have had clients who have tried to provide information to us that was obviously falsified. That is also, I think, part of our duty to investigate. We have never submitted falsified evidence to the court. I do know of some attorneys who have, and I do know that we, at one point, were sued by a client because we did not submit falsified evidence to the court. The client, of course, lost on that. But you need to know, as an attorney practicing family law in California, that oftentimes you must have a good faith basis for what you're doing, and you should be investigating the facts that your client is asserting, trying to find ways to corroborate what that client is telling you. And if it's something as simple as an income and expense declaration where you could be looking at profit and loss spreadsheets, where you could be looking at balance sheets, where you could be looking at past tax returns, although we usually don't trust the tax returns too much in family law. Look at them. Look at them before you file that I&E, and don't hesitate to ask your client hard questions. That is now, thanks to OShea, part of our job. Thank you.